Hello class, and welcome to the Week 8 and final lecture for Introduction to Law. This week we will be covering chapters 15 and 16 of your book, which is Criminal Law and Criminal Procedure. To begin with, criminal law is a situation in which public standards are violated and the public welfare is injured. The government prosecutes on behalf of the people, and penalties, with the exception of restitution, are paid or served to the public. Although many crimes result in injury to specific victims, such injuries are personal and are typically dealt with in civil actions, such as those for tort or breach of contract, which we have discussed previously. In addition, the government may prosecute for the violation of the criminal law. To begin with, it is a constitutional requirement that all crimes be stated by statute before the conduct described will be considered criminal. These statutes break down crimes into elements, and each element must in turn be proven beyond a reasonable doubt by the government in order to convict someone. The two basic categories of crimes that we will discuss are felonies and misdemeanors. A felony is any offense punishable by death or imprisonment exceeding 1 year. A misdemeanor is a crime punishable by fine or detention of 1 year or less in a jail or an institution other than a penitentiary. And states have further divided these felonies and misdemeanors into various subclasses, and these subclasses are generally used for sentencing. And, in some cases, a mandatory sentence will be required. This means that a judge has little or no discretion to impose or suspend a sentence. The statute prescribes exactly what the sentence must be. Otherwise, the judge will generally be given a range of punishment that will adequately punish the defendant for the crime committed and allows consideration of the circumstances of each case. Earlier, I discussed how crimes consist of various elements that must be proven beyond a reasonable doubt. Well, these elements can further be broken down to the elements of criminal conduct, and almost every statute or every criminal statute will involve both of these. The first element is the actus reus, which is physical conduct. This is a Latin term that means wrongful act. The next element is the mens rea, or the mental conduct of the person. This state of mind element requires a certain degree of intent to commit the wrongful act or omission. And your book draws a distinction between how the mens rea element were satisfied historically and currently under the modern approach pushed by the Model Penal Code. Historically, crimes were divided into general intent crimes and specific intent crimes. Now, we have finally honed this so that we have a negligence, recklessness, knowledge, and purpose type of mens rea that must be shown depending on the crime that is charged. For example, the crime of murder under the Model Penal Code is defined as the knowing or purposeful killing of another human being. As you can see here, the mens rea would be either knowledge or purpose, whereas the actus reus would be the killing of another human being. It should be noted, however, that there are some crimes that do not have a mens rea element. These are known as crimes of strict liability. These are established to protect the general good of society. Crimes of strict liability generally do not require preconceived intent to do or not to do a particular act. They are usually applied when someone's preventive measures could greatly reduce social or public harm. For example, when selling liquor to minors. Additionally, one who assists in a crime can also be accused and convicted of criminal conduct. And under the common law, there are 4 basic categories of participants in criminal conduct. These include principals, accessories after the fact, and accessories before the fact. To break down this concept a little further, the first category, the principal in the first degree, is the party or parties who actually take part in the criminal act. It is necessary that they perform the actus reus and that they have the adequate mens rea at the time that they commit the crime. Also, persons who possess the mens rea but convince another to perform the actual physical conduct can also be charged. Principals in the second degree are persons who actually assist in the physical commission of the crime, or persons whose conduct enables the principal in the first degree to commit the crime. If the conduct of the parties required to complete the crime successfully, either at the moment of the crime or immediately before or after, then the person who would be considered a principal in the second degree. Accessories, which are people who aid the principals before or after the crime, are divided into two categories as well. An accessory before the fact are those persons who enable or aid the principal to prepare for a crime. Their conduct may consist of providing the principal a place to plan or wait until the time has arrived for the actual commission of the crime. And accessories after the fact are persons who assist in the successful escape or concealment of criminal activity. Persons who are closely related to the principal are an exception to that rule. Under the common law, it was considered detrimental to the family unit to prosecute someone for aiding his or her spouse or children. Therefore, those persons could not be charged as accessories, and this exception is still recognized in most states. And usually, the division into principals and accessories applies to felonies. In a commission of misdemeanors, all who are involved are considered equally guilty. And today in most jurisdictions that follow the model penal code, it is no longer required that you convict the principal before you can convict the accessory. The next type of crime that you should be aware of are inchoate offenses. These are crimes that occur before but facilitate or enable other crimes. These crimes include conspiracy to commit, attempts to commit, and solicitation to commit criminal acts. And we will discuss each in a little detail. Conspiracy involves the cooperation of two or more people in planning and completing a crime as a joint undertaking. Conspiracy is in and of itself a crime distinct from the additional criminal act that is the common goal of the party. Under the common law, conspiracy had a mens rea requirement of specific intent, and each party to the conspiracy must have intent to agree with the other parties. The agreement must be to accomplish something that is illegal, and most statutes require that at least one party to perform some physical act that demonstrates his or her intent to be part of the conspiracy. It's important to note that this is a crime separate from the offense that is the object of the conspiracy. The actus reus is the agreement between the parties to commit an illegal act. The mens rea is that there has to be either a specific intent or knowledge or purpose to achieve the agreed upon criminal act. And the other actus reus requirement typically is that there has to be a substantial step in furtherance of the objectives of the conspiracy. Next, we have an attempt. An attempt takes place when a person has a mens rea to commit a particular crime and indicates a willingness to complete the crime. It is not in the interest of society's goal, however, to condone even attempts at crime. Moreover, sometimes injuries result from a failed attempt, for example, attempted murder. If someone takes material steps toward a crime, then an attempt can be charged. The question the courts must determine in cases of attempt is, how far must an individual go toward the commission of a crime before the individual is considered guilty of actually attempting the crime? One test is proximity. The court considers how close the defendant was to completing the crime. The closer the defendant is, then the less likely he or she would have turned away before completion. Adequate proximity to completion of the crime means that it is probable that the defendant would have completed the crime if given the opportunity. In a variation of this standard, some courts examine the individual and determine whether that particular individual would be likely to commit the particular crime. The court may also examine whether the defendant had control over all the necessary elements to commit the crime. Unquestionably, a person cannot be convicted of attempt if his or her actual goal was not criminal. Under the Model Penal Code, to be convicted of an attempt, the actor must take what would be considered a substantial step towards completion of the crime. And a substantial step is defined as something that makes the crime more than a contemplation. Finally, we need to discuss the final inchoate offense, solicitation. Solicitation is the act of enticing, inviting, requesting, urging, or ordering someone to commit a crime. Solicitation is a crime wherein an individual seeks to persuade another individual to commit a crime. The Model Penal Code actus reus in solicitation is pretty similar to the common law. And the actus reus is any conduct that would demonstrate an encouragement to commit the crime. The mens rea requires that the person be aware that the encouragement is for a criminal act. Further, to prosecute for solicitation, it must be proven that the person has an intent that would be required to actually commit the offense that is encouraged. Moving on, I'd like to briefly touch on the specific crimes that can be charged, and these include felony crimes such as assault, battery, theft, homicide, or electronic media crimes such as cyberbullying, public safety issues, identity and asset theft, and so on. The important thing to note about all of these crimes is that you need to be aware of what the elements are, what the mens rea is, what the actus reus is in order for a conviction to occur, and then you must apply the facts in order to see that if a prosecutor could convince a jury that beyond a reasonable doubt each element of the crime was satisfied. And if all of those elements are proven, and a conviction might be warranted because the prima facie case was established, then we need to discuss about some possible affirmative defenses that defendants may be able to raise in order to exculpate themselves. The first distinction that we need to make is between justifiable conduct and excusable conduct. Justifiable conduct is an act that takes place under special circumstances such as the defense of oneself or others. Excusable conduct refers to acts that would be considered criminal but for the actor's status at the time of the act. Of course, this may not apply if such persons abuse their authority and commit these acts without basis. An important way to draw this distinction is something that is justifiable conduct is something that the law has said even though you commit a crime technically, because all the elements are satisfied when you do this act, it is justifiable and we would prefer that you do this in order to prevent a worse harm. So a classic example of justifiable conduct is self-defense. In self-defense, you may end up killing the person that is attacking you. However, the law has made a judgment that in such cases, it is better that you be allowed to defend yourself by committing a crime, whether that crime be assault or even murder, rather than allow somebody who has wronged you by instigating violence against you from harming you. Compare that to an excuse, which is an act where a crime has been committed, however, there is something about the situation that makes it unfair to hold the actor criminally liable. For example, we can think of duress, which in the crime of duress, perhaps we do not want people committing crimes because they are pressured to do so. However, we understand that it is difficult to make a decision not to commit the crime when you are being held against the fire. Another example of an excuse defense is insanity, which is obviously we do not condone the conduct. However, if somebody is truly insane such that they cannot appreciate the wrongfulness or right of their actions, then we will excuse the conduct. And with that discussion of some affirmative defenses, we will now move on to the final chapter of your text, chapter 16, and a discussion of criminal procedure. All right, and to begin our discussion of criminal procedure, I'd like to note that most of this law that we are going to discuss involves the application of the 4th, 5th, 8th, and 14th Amendments. Since the 14th Amendment passed in 1868, it has played a controversial role in criminal procedure. Before this point, the amendments to the Bill of Rights applied only to the federal government. However, through a doctrine known as incorporation, the Supreme Court read the 14th Amendment to mean that the amendments of the Bill of Rights and the Constitution in general, in some cases, actually apply to the individual states through a process known as incorporation. This means that to a large extent, Supreme Court case law governs the field of criminal procedure and what police and prosecutor actions are or are not unconstitutional. So to begin, let's discuss breaking down these amendments and how they affect criminal procedure. The first and perhaps most significant amendment that governs the way that criminal investigations are accomplished is the Fourth Amendment. The Fourth Amendment makes unconstitutional unreasonable searches or seizures. It also sets forth the requirement in order to obtain a warrant. Evidence that is obtained in contravention of the Fourth Amendment is not permitted to be introduced against the defendant at trial under the exclusionary rule. However, this exclusionary rule is not necessarily all-encompassing. For example, in the United States versus Leon, there is a major exception to the exclusionary rule. Observing in that case that the police had made every effort to follow the requirements to protect the defendant's Fourth Amendment rights, the court reasoned that because this was the entire goal of the exclusionary rule, it had been satisfied. Basically, the Fourth Amendment prevents the police from seizing what a person considers private without obtaining probable cause. And in most situations, to be a constitutionally permissible search, the law enforcement officers must have a warrant from a judicial officer saying that probable cause exists to seize the item. And probable cause falls within a range that when examined by a neutral observer would be considered to be more than a basic suspicion, but less than evidence adequate to justify conviction. And in order to allow police officers to make the determination of whether probable cause exists, and therefore the search is constitutional, as opposed to a judge, and in doing so issuing a warrant that allows the police officer to search, there must be some sort of situation that exists that makes it impracticable to get a warrant. Thus, that we say that there are certain exceptions to the warrant requirement that police officers secure a warrant in order to make a search valid or constitutional. Generally, there is not an exception to the warrant requirement when a private residence is being searched. Another exception to the warrant requirement is where the evidence of criminal activity is seen in plain sight. For example, if an officer is lawfully on another's property for any reason and discovers criminal evidence in plain view, the property may be seized immediately under this plain sight exception. Consent is another exception to the warrant requirement. If somebody who owns a piece of property allows the police to search it, then that person cannot later claim that the officers violated his Fourth Amendment rights. And courts have also made an exception for officers to search the areas of a car that are within the reasonable reach of the owner when a stop is made to protect the safety of an officer. And when an arrest is made based on probable cause, the officer may search the arrested person in all areas within his or her reach. The primary reason for this is because in these situations, the person arrested could perhaps have a dangerous weapon on them to injure the officer, or they may seek to dispose of evidence while a warrant is being secured. The Fifth Amendment has several protections that are deemed to apply to the states via the process of incorporation that we discussed earlier. The first one of these that we should discuss is double jeopardy. Double jeopardy is the right of every citizen to be tried once and only once for a specific crime charged. It is important to note, however, that this only applies on a per-sovereign basis, and a sovereign in this context means that if an act in a mental state would constitute a crime under state and federal law, and a state law court acquits the defendant, the federal court may attempt another action to convict the defendant, although the state court would, of course, be barred by the doctrine of double jeopardy from doing so. This right attaches in a jury trial when the jury has been sworn in. In a bench trial, this right attaches when the first witness is sworn in. And attaches in this context means this is the time in which After the right attaches, the defendant cannot be charged with this same crime again. The next right we need to discuss is the right against self-incrimination. Under this amendment, no person may be forced to give information that may be used to convict that person of a crime. This principle reached its zenith in the case of Miranda versus Arizona, where the Supreme Court held that every person accused of a crime must be informed at the very outset that all further communications might be used in a prosecution. And I'm sure all of you are very aware of the Miranda warnings that are given in every episode of every television show in which somebody was charged with a crime. You have the right to remain silent, and so on. This right against self-incrimination originates at the moment that an individual is held for interrogation or placed under arrest, whichever occurs first. Therefore, all persons detained are placed on notice that any utterance against them can be used against them. And it's important to note that this right to have your Miranda warnings given to you only applies if the defendant is both in custody and subject to interrogation. So if the police simply arrest someone but don't ask any questions and don't interrogate them in any fashion, and the defendant voluntarily confesses at that point, then the Miranda warnings right would not be violated and that statement could be introduced against them at trial. However, in that same situation, if the police officers asked them a question after the arrest had taken place, then warnings would have to be given or else the statement would not be admissible at trial. And if the police wish to interrogate an arrestee, then they must either allow an attorney to be present on behalf of the accused or be able to demonstrate later that the prisoner waived the right to have an attorney present. Moving on, we need to examine the role that the Sixth Amendment plays in criminal procedure. There are three rights guaranteed to defendants under the Sixth Amendment that you should be aware of. The first is the right to a speedy trial. Judges use a four-factor test to determine whether a speedy trial was given. This test consists of the actual time of the delay from arrest to trial, the reasons the government has cited as the basis for the delay, whether the defendant requested a speedy trial at any time before trial, and whether the delay caused any harm to the defendant. Another right under this amendment that has gained increasing prominence through a series of court decisions in recent years is the right to confront witnesses against oneself. Because not every person accused of a crime can adequately confront his or her accuser, this has been determined to be a critical stage in the prosecution that requires assistance of counsel at any point in which the defendant is in jeopardy of accusation by a witness. And for the protection of several necessary rights, counsel must be available at all points in a prosecution where there is an opportunity for unfairness or where untrustworthy evidence may be obtained. Unless there are compelling circumstances, any accused person is entitled to have an attorney present at the time a witness is asked to identify the accused as one who committed a crime. Finally, we will end our discussion of this chapter, and indeed of this course, with an analysis of the Eighth Amendment. There are two rights in the Eighth Amendment that we need to discuss here. The first is against excessive bails, and the second is against cruel and unusual punishment. Courts use several factors to determine bail in order not to run afoul against the prohibition against excessive bails. And these include things such as past criminal history, past bail history, connections to the community, danger to the community, and the likelihood the accused will try to flee. And finally, essentially, the Supreme Court has defined due process to include the protection of the Eighth Amendment with regard to prohibiting the imposition of sentences that are cruel and unusual. And cruel and unusual can be examined in a case in your text, the Bays versus Rees case. In that case, two Kentucky inmates challenged the state's four-drug lethal injection protocol. The method used in this case was technical, but more or less called for the administration of four drugs: Valium to relax the convict, sodium pentothal to knock the convict unconscious, Pavilon, which stops his breathing, and potassium chloride, which essentially put the convict into cardiac arrest and ultimately caused death. The Kentucky Supreme Court held that the death penalty system did not amount to an unconstitutional, cruel, and unusual punishment. The issue up for the Supreme Court was, is the use of a four-drug lethal injection process to carry out death sentences a violation of the Eighth Amendment ban on cruel and unusual punishment? And the law of this area is that punishments are cruel when they involve torture or lingering death, something inhuman and barbarous and more than the mere extinguishment of life. Applying this law to the facts, the Supreme Court held that Kentucky's lethal injection scheme did not violate the Eighth Amendment. They noted that the inmates had conceded that the humane nature of the procedure when performed correctly. However, the divided court intimated that the court had failed to prove that the incorrect administration of the drugs would amount to cruel and unusual punishment. The court suggested, however, that a state may violate the ban on cruel and unusual punishment if it continues to use a method without sufficient justification in the face of superior alternative procedures. And with that, we have reached the end of the course material for Introduction to Law. It has been a pleasure providing these lectures for you, and I wish you good luck on your finals.